There we go. Okay, it took a little while. Okay, great. Little delay. Well, good afternoon, everybody, and welcome to the Insurance and Legislation webinar. Today, we're going to talk about how new laws affect community associations' D&O liability coverage. I'm Marketing Manager Sherry Branson of Kevin Davis Insurance, and I'm now joined by Kevin Davis, the president of Kevin Davis Insurance. Hey, Kevin.
Hey, Sherry, how you doing today?
Doing great. Kevin, you're on the East Coast. Haven't seen the East Coast in quite a while.
Yeah,
Both
it's funny. And normally I say good morning to you. I said, no, it's 2 o'clock in the afternoon here. It is funny. Yeah, it's different,
yeah.
isn't
Yes, it is. It really is different. We're adjusting to both to the East Coast time and you're getting used to the East Coast heat.
it?
It's a little bit warmer on the East Coast.
It's warm. It's warm. Yeah.
Mhm.
Yep. And it's humid here. Unlike LA, where it can be 90 degrees, but a nice cool breeze is coming here. Here, 90 degrees, it says it feels like 102. So,
Uh-huh.
yeah,
Mhm.
yeah. Not
Oh,
used to that. Not used to
yeah.
that at all.
I know what you mean. It takes a lot of getting used to. And
Yeah.
Kevin, today we have a great group with us. We have people
Yeah.
joining us from all over the country.
Yeah.
I got a lot of questions about this when I was sending the emails out about signing up for today's webinar. There's a disclaimer on the screen. If you could please take a minute to read that disclaimer. And we've got a great group. We have over 200 people joining us. So today's a topic that everybody really wants to hear about, these new laws and how they're affecting basically, we're going to talk about a few states, but they're really going to be affecting the whole country, we believe.
Yeah, yeah. This is one of those topics that scares me as a DNO underwriter, as a DNO program administrator, because these new legislative trends that we're seeing. And again, it's limited to a few states, but we know it's going to grow, it's going to expand. So we're going to talk about them and how it impacts the DNO in terms of maybe rate or coverage. So we'll, it's going to be interesting, and we're going to have to be a little more technical than we normally are on these things. We talk about some of these laws and some of these changes, but no, I'm looking forward to it because this is something that our goal really is to bring awareness to people who are listening today that these are some issues that really going to impact your DNO no matter what. And this, I'm not the only DNO person right now who's concerned about this, but every DNO person out there who handles community associations are looking at these legislations and saying, how are we going to handle this from a coverage premium point of view? So yes, okay,
Absolutely. These
hmm
are big changes, Kevin, and we haven't talked about this before. This
yeah,
is the
yeah,
first time we're going to
hmm
talk about it.
yeah. Okay.
So we're talking about, the new legislation. So what are these new laws that we're going to talk about
Okay.
today?
Well, we're going to talk about our three, kind of put them in three categories. Number one are the structural integrity issues. Number two is the reserve set of requirements, and number three is I call it consumer protection, which is basically the Corporate Transparency Act. These are the things that I get a lot of calls from. People want to know what my thoughts are on it, how we're going to handle it, and they're challenging. They're really challenging for all of us who are in insurance, especially DNO insurance. So let's start with the structural integrity laws that are happening out there right now. A lot of this is because of the Surfside tragedy, which is what 3 years ago.
Yes, this week is the 3-year anniversary.
Yeah. And so we talk about the laws are in Florida right now, New Jersey, and California. And these are all just to deal with the structural integrity that happened in Surfside. So let's start with Florida. Florida passed something called Senate Bill 154. And the reason is again, to make sure that these community associations are structurally sound. And the key thing here is based on two parts. Part one is a milestone safety inspection. A milestone safety inspection, and it has to be for every community association that's over 3 stories
Okay.
and 30 years or older.
30 years old.
Okay.
And
Okay.
Kevin, maybe for people who are joining us today, maybe somebody hasn't heard of what a milestone inspection is. Could you discuss that a little bit?
Sure. It is pretty, it's not that complicated. It is a specialist has to go out there, okay, and do a visual inspection of the property and determine the structural condition of the property to make sure the load bearing walls, make sure everything looks okay. That is phase one. If everything's okay in phase one, they get the right report, and there is no phase two. If there's a phase two, that's where the problem occurs. That means they found something, some structural damage. They found maybe the balcony is having some issues there, or maybe the garages are having some issues there, some issues there that they need to be addressed. And then once they get that, they have to be addressed. That means they have to go out and get reserves. They have to go out and maybe a loan, whatever it is, it has to be fixed. That is the law. So that's part one. Part two is called this SIRS, which is a structural integrity reserve study. Okay, a structural integrity reserve study. I like to call that a reserve study plus. Most associations understand reserve studies are. This is a reserve study plus. They have to do it every 10 years. Okay, for all the building in 3 stories or higher. So that is right now the number one issue we're seeing right now in Florida is that you must comply, and surveys must be done, inspections must be done by December 31st, 2024 for every association existing before 2022.
Okay, so that's
Okay.
6 months away, Kevin. So
Yeah.
that's a real time crunch for
Yeah.
lots of associations to get up to speed on all of this.
Yes. Yeah. So that's number one. That's the big issue right now. They have to comply. So you have all these associations. I mean, in Florida, they have about 30,000 community associations. I have no idea how many are 30 stories, 30 years old or more. But again, they don't have a choice. The second one is New Jersey. New Jersey has a similar legislation based on 2 parts. They have a structural inspections, and they have to have a reserve study, and they have to fully fund the reserves.
Mm-hmm.
Okay?
Okay.
Now, the way they operate is that they have to do structural inspections for a certain type of buildings. They call them covered buildings, and they have to be 15 years or older. Where Florida, they do 30 years. In New Jersey, they do 15 years, but they're limited to what's called covered buildings.
Okay. Now, can you explain what is a covered building so people know what you're talking about?
Sure. These are the buildings that are made of concrete, masonry, steel, of that nature. So
Okay. Okay.
again, I'm not a lawyer. I'm just saying that these are the issues that as a program MGA of DNO, you have to comply. And again, this date is very, very important date. Again, they have to do it by the end of the year.
Mm-hmm. Okay. So time is of the essence.
Time is of the essence. The third one, and again, we're talking about 6 months. July 1st is next Monday. Yeah, it's coming up fast.
Some on vacations and things like that. Yeah, it's going to go by very quickly.
Mm-hmm. And the next one we have is in California. California has a balcony inspection law that went into effect on January the 1st, 2019, but all inspections must be completed no later than January 1st, 2025. It has to be done every 6 years.
Okay, so that's another one that's 6 months away.
Yeah, these are all 6 months away. Okay, and you have to comply. So all the associations out there that have to comply. Okay, so that's number one, structural integrity.
Okay.
Number two, reserve study requirements. Now, every association out there has a fiduciary responsibility to maintain the association. That means they should understand that certain things they have to do. They have to make sure the roofs have to be repaired. They have to make sure that the sidewalks, all that things has to be done. And normally the way you do that, you get a reserve study and you fund the reserve. They tell you what needs to be replaced and how long it takes to replace it and how much it's going to cost. So this happens in every single state. Every association should be doing it. So when we talk about this, the reserve study requirements, the difference today is that 18 states are requiring it. So they either require a reserve study, or B, just to be reserved, okay, fully reserved, or some kind of combination of the two. Okay. So 18 states are required. So again, we're talking about compliance. Okay. Right. So once these things happen, you have to do something about it. And that's what we're talking about. Again, from a DNO point of view, when you're forced to do something, it makes it a lot different than when you know you should do something, or you should do something. Every association should have a reserve study and fully fund the reserve. Right. Now you have 18 states that says you don't have a choice.
Right, right. And the board members, now if they're not aware of these laws, that's where a big problem could could come along if they don't know
Oh,
these laws are in place.
we're going to talk about that, what happens next. Okay, so one more left, and that is the Corporate Transparency Act. The Corporate Transparency Act was passed by Congress on 2021, and requires community association to provide detailed information about their owners, their names, addresses, unique identification information, such as passport or driver's license, along with picture and other kind of documentation. Okay. Now, failure to comply with this can be $500 per day, up to $500 per day, criminal penalties up to $10,000, up to 24 months in jail. Okay.
Wow.
Uh,
Okay, so this is
and,
a serious law with
yeah.
serious consequences.
And guess what the date is of this is?
Let's guess. Is it
January
December
1st.
31st or
No, this is
January
January 1st. You
1st?
get one extra day on this one.
One
January
extra day,
1st,
one more day.
2025.
Wow.
And now, the interesting thing about this is that I'm getting a lot of calls because they hear that, guess what? The CTA, the Corporate Transparency Act, was found unconstitutional in Alabama. Okay. This was just happening a few months ago. That's only in Alabama for I think it's called a National Small Business Association that filed the claim. So guess what? They don't have to comply because they found it was unconstitutional for them. The rest of everybody else has to comply.
The rest of the country has to do it.
Yeah.
Just one small group because they challenged it.
Exactly. So that's the problem we are facing right now. When you're looking at these issues right here, those three big issues, these are laws that the association has to comply with. Now, let's talk about our D&O policy, and not just our D&O policies, our competitors' D&O policy, any D&O policy you have that's covering community associations right now. If you look at what D&O covers, it's the insured for loss because of a claim for a wrongful act made against them and a right and duty to defend any claim covered under the policy. So you're looking at three issues there. You're looking at the insured, which is the board of directors, because of a claim, which is a written demand for monetary or non-monetary damages for a wrongful act. And a wrongful act is any act or omission. So not complying is a wrongful act. So a claim against that board of directors for not complying meets this definition. Now, there are exclusions in the policy, there are other terms and conditions in the policy. I'm not talking about that right now because everything is going to depend on the claim. However, those three things are critical right now because you have an insured, you have a claim against them for wrongful act. Now, when I talk about a claim against them for wrongful act, a claim is a written demand for monetary or non-monetary relief. When we're talking about what does that mean to us, it means if there's a non-monetary damage claim, we're talking about a frequency problem. If we're talking about monetary damage claim, it's going to be a severity problem. Okay, so that's the two areas that we're looking at in terms of types of claims we're going to see. Okay, so all right, we got that. We're all there now. So now let's go into the important thing. Okay, and here's the question. And this is the question that we get asked, and I ask my underwriters, and I talk to, my competitors. Can this lead to catastrophic litigation? And that is the question. Again, I'm talking about monetary damages and non-monetary damage. Non-monetary is frequency problems and monetary is severity problems. So right now they have a job. They have to ensure compliance with these three things to avoid penalties, avoid being sued. Okay. These are the three problems right now that we see that says some of these won't be in compliance. Number one, there's a lack of knowledge and experience. The lack of knowledge and experience because guess what? These are volunteer board members that they don't actually know about SB 154. They may have looked at it, they may have seen something, but they may not know about it.
Right.
The manager they have may not know about it. And it is so complicated right now and constantly changing because even if you do know about it, it's changing. Nobody really knows enough about it. I said nobody. Most people don't know enough about it to say if I'm fully compliant the way I should be. So right now, yes. So right now, these board members have to rely on specialists to say, guess what? You are in compliance. They cannot make the decision. They have to go to specialists and say, I am in compliant. Okay, they got to do that. Right now, they have the lack of experience and knowledge, so they may just ignore it. The second thing, they can't afford it. It may cost $10,000 to get specialists out there to do your milestone inspections, you know,
Right.
or any kind of inspection, you know. And right now they may not be able to afford it. And
Hmm.
again, if you can't afford it, that puts you in that area of non-compliance.
Hmm.
And then the biggest problem right now that we're seeing, however, now the good news is this. Well, I've been making some phone calls lately in Florida, talking to reserve study specialists, talking to attorneys and managers, and it looks like there are specialists out there who are doing this and taking care of it and on top of it. So that's the good news. But again, you may not have enough specialists out there to do all the inspections and all the reserve studies that are necessary. But from what I'm hearing, that is not as big of an issue as I thought it would be. But again, you still have three things going on right now that is really truly creating a problem. We just don't know what do you mean SB 154? You know, we can't afford that. And guess what? We're in a line and we're 6 months before it gets it done. So, and again,
Right.
we're facing that deadline, you know,
Right. Right.
December 31st, January the 1st. This is
Yeah.
all the things that's going on right now. So,
And what comes to mind, Kevin, is too, like a lot of these associations, the high rises, have put off this maintenance work and structural integrity work for years, so then now all of a sudden they get hit with a huge bill, a huge estimate on what they have to do to make the building safe and secure. And then the reserve, the special assessments are going to be huge. And it's really, it's
and that's the issue right now, Sherry. And we'll talk about what kind of claims we're going to be seeing. Okay. Sample types of claims. Again, I'm looking at severity and frequency as the problem. When I talk about non-monetary damage claims, these are claims that where a unit owner or somebody who lives in an association, it doesn't actually be an owner there, but anybody there who says, you know what, I am concerned. I saw this billboard up there on my way home that said, asked me the question, are you complying with SB 154? And I don't know if we are or not. So I go to our board and say, are we in compliant? And they say no. Well, guess what? I want you to be compliant. So I'm going to make a claim against you, board directors. Okay. Uh, just a claim says you need to be in compliance. You know, not only need to be in compliance on SB1, but you also need to do other things also. Because normally they'll give you a laundry list. I mean, if you live in a community association, we know there's always one person in there who keeps track of everything that has to be done. You know,
that's
the
right.
guy who leaves their trash can out for 48 hours, or puts it in on a Monday, and that's supposed to be on a Wednesday. You know, that one guy who notices that my car is in visitor parking this time. That one guy now, he also knows you're not in compliance.
Right. They have a
So
checklist going off their
he,
check. Yeah.
so he's going to start a lawsuit. He's going to go after the board of directors, say you failed to comply. And as a result of you failing to comply, you're doing damage to our association. Okay. I want you to comply. I don't want any money. I'm not suing for any money. I'm suing because you are not doing your job properly. And that's my job as a person who lives there. And every community association in the country has that one guy in there who does one thing and checks, has a list of all the requirements of all the rules and regulations association. And every time one's not being enforced properly, they go to the board and they complain. Now they're going to file a lawsuit. And an attorney who all of a sudden sees that you're not in compliance, guess what he's going to do? He's going to say, all right, I'm going to make some money off this one. Because he
Hmm.
knows you already lost this case. You already lost it
Right.
because you're not in compliance. You're not
Right.
in compliance in a lawsuit against you. I'm going to have prevailing party fees. That means I'm going to get the money for it. So we're talking about frequency issues here when non-money is involved. Frequency issues because the board is not doing their job. They breach their fiduciary duty because they're not in compliance. And they're not removing the trash cans. They're not minding the pool hours. They're doing a lot of stuff they're not doing. They're incompetent. They're doing. These are the kind of claims we're going to see. The same thing with the CTA, the same with reserve studies. No matter what it is, you have that one person in the community association doesn't like what they want to do and sue. You may have a group of them and do a derivative action suit that says, guess what? We're all going to sue on behalf of the unit owners. We're all going to sue. So
Hmm.
these, again, they're frequency problems because they're not saying we want millions and millions of dollars or thousands and thousands of dollars. So that's your frequency issue. Now, on the severity side, what I'm concerned about is now all of a sudden they're suing for damages. You know, I hate when I hear that word, suing for damages. And the damages are this: because you haven't complied, guess what? My unit is not worth what it should be worth.
Right.
You know, my
Right.
unit's not worth that $300,000 anymore because
Mhm.
you haven't complied, so it's worth less now. If I was in compliance, instead of be worth 300,000, it should be worth 400,000. But
Mhm.
because you're not, I have economic losses. I suffered damages. Or
Mhm.
guess what? I can't sell my unit because
Right.
nobody's going to buy a unit if you're not in compliance. So I'm suffering damages. But not only I'm suffering damages, but my neighbor wants to sell and he's suffering damages, and one across from me is suffering damages. So
Mhm.
it is a serious, serious issue right now, because of non-compliance. Non-compliance right now is a problem, and we got to make sure that these associations are compliant. Now, if they are compliant, guess what? They still have issues. They still have issues. They still could be
Right.
sued.
Even if
They
they do comply. Yeah.
Yes. Still could be sued saying wasted corporate assets. We don't have enough money. We,
You're
how
raising our
dare you just buy?
fees.
Exactly, exactly. You don't have the authority to do it. All these different things you're going to see anyway. But guess what? All you say you have a great defense. Your defense is, listen, I'm just obeying the law.
Mhm.
That's all. It's my defense. I understand this, but the law says I have to comply with these situations. Now I'm in compliance. And I know, we have financial issues. I know we have all these other issues, but right now compliance with the law is number one. That way I can avoid my breach of fiduciary duty. Okay. And guess what? We don't know if it's covered or not. I want to make sure that I, as a board member, is protected.
Of
Yeah.
course. Yeah. This is where the attorney for the association really comes in handy, speaking to the association attorney to find out, to stay in tune and up to date on what the laws are, and to make sure that you, like you said, you're fully compliant and you meet the deadlines, et cetera. So you are protected, and the D&O is going to cover you when you are making sure that you're doing everything properly and making the deadlines, et cetera, and complying with all the requirements.
So now let's come to the tough conversation part. This is potential outcomes. And again, we have no idea what's going to happen because we're still looking at the different things. And I believe all my competitors are looking at this, trying to figure out what we're going to do. What can they do? Number one, this is one thing that we're thinking about: updating the application requirements to see, are you in compliance? Are you fully funded? Do you have a reserve study? Number two, give me a copy of it. We want to see a copy of your reserve study. We want to see a copy of your compliance documentation. We want to see these things. Higher premium for high risk associations. So those ones that are over 30 stories, they can be. Exclusionary language. Maybe we can exclude some of those things in there, certain things. Specific exclusionary language in there. We could do that also. Or increase deductible for non-compliance. So these are the things that we're playing around with to see. And I bet you any amount of money right now, all of our competitors are sitting in the room right now and saying, how do we handle these situations? How we can avoid them? What can we do to limit these losses? Because again, we're talking about what? Frequency versus severity, and they both can be a problem. Frequency, I have a lot of different claims of this that may cost me 10, 15, $30,000, but it could be a lot of them. That severity problem, again, it can be hundreds of thousands of dollars, a lot more money. So, and again, we'll see both of them, but the way the policy is, because we cover economic losses and non-economic losses. Critical right now. It's critical.
Hmm. Yeah, that's why D&O insurance is more important than ever.
Yeah.
We've no idea. And to be
So,
aware of what's going on.
so let's do this. Let's go through some tips there. Tips to avoid these kind of claims and new legislation. Because again, what we want to do, and again, people who are listening, let your managers know, let the associations understand that you can't walk into a situation thinking automatically that I have a breach of fiduciary duty and therefore there will be coverage, because you don't know. We don't know until the claim comes in. So you have to do some risk management. So these are some risk management techniques that you can send out there, so that if they do get sued, they want to make sure that instead of being way up here, it can reduce. Our job right now is reduce it. Is reduce that likelihood of a claim happening. And if it does happen, it's not going to cost because we don't know what the future looks like for this new legislation. Okay, so number one, we're talking about understanding and complying with the law. First thing, you have to be aware that these laws exist. And awareness is number one. And then you have to be able to get the specialists out there to say, please make sure I'm in compliance with these laws for my own protection. Okay. Number two, engage in ongoing education. If you are a board member, make sure you attend. Community Association Institute has given me a lot of information about these laws and what's happening right now. CAI. If you don't know how you get this information, go to CAI and they will help you to get that education. The only way that you can really do your job effectively if you understand what your roles and responsibility is as a board member. And number three, document, document, document. Because what's going to happen when that board of directors or that unit owner comes to you, board member or past board member, saying, you did not do your job. I can see right now you're not in compliance with SB 154. You can say, listen, I have a note saying that we're number 10 on the list and we'll have it done in a few months. And guess what? That alone is enough to sit back there and give you a little bit of peace of mind because you are aware of it and it just helps you out. It's defendable. Okay, what you're looking for is a defense so that there's no economic loss against you. You might have to pay some defense costs, but you want to avoid those economic damages.
Mm-hmm.
Foster transparency with the members. Right now, it's important that not only you document and get education, but educate the people who live there. Let them know what's going on. Let them know you need to be in compliance with these laws for the benefit of the association. The health, safety, and welfare association depends on you complying with structural integrity issues, complying with reserve study requirements, complying with the CTA. So you have to do these things, but the only way you really can do it is by fostering transparency. You have to have that communication with board members and unit owners to say, these are the issues right now, and these are what we face. We understand right now we have financial concerns, but we have to be on top of it.
Right. If the homeowners know that it's a law, it's much easier to ask for that information with the CTA, and it's also just easier to make all these changes, and they're going to understand why you're asking. You know what I mean? Rather than just hitting them with an email or a letter saying we need this and we need that. I mean,
but it's interesting you just said that, especially with CTA. You're going to have people who will read it and understand it, but don't accept it.
Won't be happy. They won't be happy with it.
Yeah, you can't give that information out. I'm not to the federal government. How dare you? But again, right. Your defense is simple. I'm just complying with the law. It's not me personally. I am complying with law because you're going to have a lot of people there who says, I have my privacy rights. You cannot give that information away.
They won't want to give it. They won't want to give it. So then you're, exactly caught in the middle.
Yeah. Mm-hmm. But again, you have you have fiduciary responsibility to comply with the laws right now. And again, that's what our recommendation based on. So conduct regular inspections. That's another thing. Just conduct regular inspections so you know what's happening in your association and be aware of it. Now, the next one's interesting. I say review and update maintenance schedules regularly. And I should get rid of review and update, have a maintenance schedule.
that would be nice. That would be, that would be important.
Mm-hmm. Because a lot of associations out there do not have a maintenance schedule. Right. And if you have a maintenance schedule, you won't have structural integrity issues.
Right. Yeah. Right. If you stay on top of it, Mm-hmm.
And finally, make sure you have a comprehensive D&O insurance policy, one that picks up economic losses and non-economic losses. Make sure you pick up the frequency along with the severity. That is the issue for us right now. And a lot of D&O policies out there will only cover damages. If you look at a definition on a lot of D&O policies, they will say the same thing. They will suit for damages. If you see suit for damages on your D&O policy, you are in trouble because it doesn't pick up claims, non-monetary damage claims. It picks up suit for damages. Okay. Mm-hmm. Whew. So what else we got there? Yeah.
Great information, Kevin. And we have a few questions, but we'll talk about those in a couple minutes. Now I'm going to talk a little bit about the risk management helpline, which is basically available for any current travelers insured with community association management liability. The slide is up on the screen right now. It's a fantastic resource and tool for all of your insureds. The phone number is there, 855-548-8656. It's available Monday through Friday from 8 a.m. to 5 p.m. Eastern Time. And basically, your insureds can call this helpline and ask questions about risk management topics. And with everything going on right now, this helpline is extremely valuable and important. So please share it with your insureds. And that's another tool in their toolbox to help them avoid claims and just make sure that they're doing things properly in the right way. And now we're going to talk about Kevin's podcast, which has been really popular. Kevin's been doing a Common Sense for Common Areas podcast for a while now with Robert Nordland. And Kevin, can you talk about your podcast a little bit?
Sure, yes. We've been doing it now for a year. We're number 60 something. We're number 60, and I do it once a month, and sometimes I do it twice a month, depending on how often I get a chance to do it. And these are all informative education, awareness about these things we're talking about right now. So yeah, hope you can attend. Go to the website. You go to the YouTube channel. There are also audio and videos, so you can find out what we're doing and everything. So
Fantastic. Great. We hope you tune in. And Kevin and I did a couple of episodes of the podcast recently. So we hope you can listen to them. They cover all kinds of topics related to community associations, everything from accounting to insurance to legal issues, which is what we're talking about today. So it's a great, great resource as well. So Kevin, do we have time for like one or two questions before?
Well, I looked at a lot of the questions, that we have. And again, I have a flight. I'm flying back to LA, and so I
Okay.
can't stay. But a lot of those questions are really detailed questions about the CTA,
Hmm.
about SB 154. I'm not a lawyer. I can't answer those questions. I can't even answer the coverage questions because I don't know. We don't know. But I tell you what we will do, okay, as we develop. I would say maybe later on in the year, maybe October, September, October, we'll do a follow-up on this on this topic so that we can give you everybody an update of where we're at, what's going on out there, because things are changing rapidly. The law is totally different today than it was 6 months ago. CTA is different than it was 6 months ago. 154 was what is different than it was a year ago. So things will change. So what we're going to do is in September, October, we'll revisit this and do an update. So how's that sound? Good idea?
That's fantastic. Sounds great.
Okay.
Sounds. Thank you, Kevin, and
And I
thank you.
saw Steve Layden, my buddy Steve Layden, has a lot of questions in there as usual. Sorry, Steve. We don't have time today to really go into a lot of the questions. We have to take a pass because I have a flight to catch. I have to get back to LA. It's been a while since I've been back there. And it's hot in New York City. In LA, it's cooler.
Kevin's escaping the heat. He's escaping
Yes.
the heat in New York City.
Okay.
Thank
All right.
thank
Thanks a
you
lot,
so much.
Sherry.
Thank you. And I'd like to wish everybody a safe and happy 4th of July from all of
Yes.
Kevin Davis Insurance. Thanks, Kevin. Have a safe trip to the airport. Thanks,
All right.
everybody.
Thanks a lot. Take care.